You've probably heard that probate is a nightmare, but what is even probate? And when does it apply? In this video, we're breaking it down in plain English. We will cover how it works, how long it takes, what it costs, and how you can avoid it. I'm Roberto Seda, an estate planning and probate attorney in Oklahoma City. My office deals with probate every day. We know the most commonly asked questions and how to help you navigate the process. And be sure to stick around to hear the most common probate myths that could cost your family time and money. The truth is that most families don't think about probate until they're in the middle of it. So let's start with, what is probate? Probate is the legal process whereby we transfer the ownership from someone who has passed away and pass it to the rightful successors. The steps can include validating a will, if there is one, appointing somebody to represent the estate during that legal process, making sure that we pay off all of the debts, and then transfer all of the ownership interests to the rightful owners. When is probate required and when is it not? Probate is required when someone passes away with an asset in their name individually and there's no beneficiary designation. In addition, that asset must either be real estate or personal property that totals over $50,000. Probate can be avoided if there is a beneficiary designation for that asset is jointly owned with somebody else, or the asset is owned by a trust. What does that probate process look like? Well, first we're going to meet with you to gather all the family information and try to identify as many assets that we know of that the decedent owned. Once we get that information, we're going to put pleadings together that we're going to file with the court. And during the first part of the probate, we're going to have somebody appointed to represent the estate. Once we get that person appointed, then we're going to give notice to creditors and give them the opportunity to file a creditor's claim during the probate. Now, if they fail to file a creditor's claim, it is potentially possible that their creditor's claim can be denied later on. Once we know all the creditors, we're going to make sure they get paid, and then whatever is left over after identifying during this process the total inventory, we're going to distribute that to the people that we have determined are the rightful owners through that probate. So what's the timeline? How long does probate actually take? Part of the process when we sit down with our clients is identifying who has an interest in the estate, what are the assets. And there are certain times that if it's a very simple estate that's under $200,000 and people get along, that probate could just take 2 to 3 months. However, if people don't get along or the total estate is over $200,000, then we're left with a regular administration. The regular administration can take anywhere from 6 months to a couple of years, depending on how complex it is, whether it's contested or not. The biggest thing to know is that it's not immediate. There will be a delay in getting these interests passed down to the rightful successors. Now, let's talk about the cost of probate. I tell people to at least plan on $4,000 to $5,000. I know that's a lot of money, but there's a reason why. You have court costs, you have publishing fees, and then you have to pay the attorney. If a matter becomes contested, there's a lot of attorney time that is required. I've had probates that are in the tens of thousands of dollars, but generally expect at least $4,000 to $5,000. Now, that unknown cost definitely stresses a lot of our clients out. And as a result, here at Seda Law Firm, we have actually implemented flat fee pricing. What this allows is for our clients to budget and plan ahead on a known cost for the probate. They love this. It is a little bit more initially up front, but it guarantees that that's all they're going to pay for that probate through completion. So what are some of the most common mistakes that I see? Probably one of the most common mistakes is that I actually see families distributing assets before a court has actually ruled and appointed somebody to do that. So everyone goes in, takes what they want, and then without knowing whether they were even entitled to it. Another common mistake is that people try to, because probate is expensive, try to do this on their own. And then they get to that initial hearing and the judge tells them they need to find an attorney. And now they've lost a month's worth of time. People need to know is that the statutes actually require certain things to be done in order for somebody to be appointed to represent the estate. And if not, a judge is not going to appoint that person. So just knowing the legal process and trying to do it by yourself causes a lot of issues. Another one is that heirs put the house on the market. They want to sell mom's house, but they fail to start the probate. What happens during the title process is that the title company is going to identify that a probate is necessary. Depending on when you're at and what kind of buyer you have, the buyer may stick it out, or you may lose a buyer because it does take time in order to get that court approval to sell that house. Another mistake is that people don't fully understand who gets what, and this causes a lot of family fighting, driving up the cost for the probate. Depending on how the family is situated, whether it's a normal kind of traditional family or a blended family, people are entitled to different interests. And because people are perceive that they should be entitled to a certain percentage, this causes fighting. Just so you know, the spouse does not get everything all the time. Now let's talk about the emotional toll of probate. Everyone grieves differently. I have sat in consults with people where I had two of the three siblings, and the two siblings were just mentioning how they didn't realize or never thought that that third sibling would react in the way that they are. What I have learned is that we never know how someone's going to react to losing a loved one until that actually happens. The way that we can avoid stress is by having a plan. So what does it mean to have a plan? The plan would include organizing all of your assets so that it's easily identifiable when someone passes. Next, let's make sure that those assets have beneficiaries so that those assets are not going through probate. Or let's put a will together. That will shows your intentions once you pass away. So there's no fighting once you pass away through your kids or your heirs as to who gets what. Ideally, though, the best plan that you can have is to have a revocable living trust. You put everything into a trust, it avoids probate. The trust itself are a set of instructions on how your assets are going to be distributed, and the trust helps avoid any fighting amongst the heirs and successors, thus limiting costs. Now, let's talk about some of those common myths. The most common myth that I hear is that a will avoids probate. It does not. Actually, a will has to be validated by a judge, and the only way that you can get it in front of a judge is to open up a probate. So that is definitely the number one myth that I hear. The next one is that my wife gets everything. She does not. If you die without a will, so that's called intestate. If you die intestate, whatever asset you have will be shared between your wife and your kids. Now, that interest could also vary if it's your first wife or it's a second or third marriage. So just know that those percentages do change depending on which wife you're on or husband. And myth number 3 is more of a pitfall, maybe not a myth, but I have seen where you have blended families, let's say a second marriage, and they buy a new home, and title is taken as joint tenancy between the husband and wife. Well, in that case, people think that, hey, I bought the house. When I pass away, my interest is going to go to the kids. Unfortunately, because it's owned as joint tenancy, that will actually go to the surviving spouse, and your kids are disinherited, maybe by accident, because of that. And then the surviving spouse, once they pass away, that house will go to their kids. Thereby, the first to die is really important. Ultimately, remember that probate is a process, not punishment. Probate is a structured way that we're trying to settle the affairs of the decedent. It is protection for both the executor, the heirs, and the creditors to make sure that everything's treated equitably. If you're not sure what your family would face if you were to pass away unexpectedly, or if you've recently lost someone and don't know where to start, we're happy to help. We offer a free 30-minute discovery call to those interested in learning more about probate and estate planning options. Click the link in the description or scan the QR code to book your free discovery call.